Well, so before I go to the audience then, I thought I might actually turn back to Lisa, because I know that working in scholarly communications in a library, one of the things that you talk about a lot is open access. And there could be a connection here, right? If things go a certain way out of this case, what are the consequences for open access? And maybe say a half a word about what open access is for anybody who doesn't know.
Well, it was actually a thought I had today, and a thought, quite frankly, that I had at trial. And open access is essentially making digital scholarship free to the reader. It is the idea that you cut down those barriers of access, both in accessibility of being free to the reader, but also copyright and license restrictions as well. And so Creative Commons licenses are a way of doing that as well. And it's something that universities have embraced, in part because we have a public mission that, our underlying mission is to generate new knowledge, and you generate new knowledge by sharing. And the more freely you can share, the more you basically effectuate that public mission. And for libraries, that's very clearly tied to a library's mission of not only facilitating that generation of new knowledge, but also preserving knowledge. I mean, we're the ones who are basically in it for the long haul, as it were. And so when I was watching the trial, I really was struck by the fact that these are works that were essentially authored by faculty. The faculty members get very little in the way of royalties. They do get royalties for books, but these are academic books. They're not textbooks. They're not big bestsellers. These folks are not, Daniel Steele or any of the other kind of big commercial publishers. And I'm pretty certain, having talked with faculty, that if the faculty member had been asked, could I use a chapter from your book on reserves for your class, they would have said yes, because it's kind of the common practice. They created the work for it to be used in scholarship. And so I did have the thought at the trial that if these books were open access, this all goes away. There is no controversy, because they would be openly accessible to the students, to the world. They could be linked to. We wouldn't be sitting here. So I do think it is another moment where we've been seeing more momentum from funders for open access, where it starts to beg the question, what does the academy do to kind of reclaim the distribution of scholarship? Because technology enables us to do that in ways that we haven't necessarily been able to in a print world. We've had university presses for a long time. They've been subject to a number of stresses in the market, although I will say I don't count Oxford University Press in that group, for the simple fact that they last year had $1 billion with a B dollars in sales. They're the first university press to make $1 billion in sales. And they had a surplus, because they're a nonprofit, of I think $180 million or something like that. A library's dream. So
clearly Georgia State is putting them out of business.
Clearly, they are putting them out of business, yeah. Yeah, the market harm arguments start to really kind of fall apart. And particularly when the judge found that 0.25%, of royalties were coming through license fees from Copyright Clearance Center. So, and I'm not saying we want to do away with university presses. That's not what I'm saying at all. Peer review has value. But I do think it's, part of kind of a reconsideration in the academy of how much control and we want to have, and what role libraries can play in helping to kind of publish content that our own faculty are producing, so that it can be freely available.
I have a comment on that, and I sort of have mixed feelings this way, but one, who would pay for the initial publications? And the other one is the question of academic promotion. Mm-hmm. And which is a big one. And it's just the way the system works right now, but you have to publish in certain journals, or if you're in subject matter, have a book with a certain university publisher. And in order to get tenure, and if you go to a situation where say, well, tomorrow we'll just make it all open publishing and that you can publish your own things and they're up, then how do you regulate that for tenure? And
Right. Well, the promotion and tenure question is a big question, and being open access doesn't mean there is no peer review. So, I mean, peer review is our kind of staple, and I don't think any of us wants to see peer review go away. But I do think the question of promotion and tenure is a big one, but also realize we in the academy make those decisions. As to which presses we will consider to be, the favored presses, as it were. And I do think that there are ways of determining impact and quality that can be separated from this publisher published versus that publisher published. But I think it's more work. And I have said before, I do think we in the academy have somewhat relegated to acquisitions editors at university presses, decisions around what really is quality, meaningful scholarship, and, can we not on our promotion and tenures committees, make some of those determinations and decisions ourselves,
Yeah.
But it's symptomatic of the fact that this is all part of one larger, big system. So there are a lot of moving parts here, and a lot of players.
Right. And so, to the extent, as Bruce said, if to the extent that the purpose of copyright is to foster this kind of progress in science and an ecosystem where that progress can happen, if this decision throws sand in the gears of that progress, I think the model of publishing that everyone is engaged in is going to start to look in tension with those goals. So open access is going to look more attractive. Okay, so this is the hard question. Let's see. I won't put it so starkly as a prediction, but I wonder if anyone dares to say, maybe to characterize what were the things that you think, based on what you saw today, and all right, I'm going to pick on Jonathan because he's my friend and he can't hate me. Not for long, anyway. What do you think the judges are thinking about right now, given what they said in the courtroom just now? What were their kind of, what were the pet issues that seemed to be stuck in some of the craws of the three guys up there in the front of the room this afternoon?
Well, as others have mentioned, I think they clearly are concerned about this quantitative issue, and was it legal error for Judge Evans to come up with sort of these bright lines? But they also recognize that the publishers were suggesting bright lines. Now, yes, that's in the remedial phase as opposed to the liability phase and the fair use determination. But I think that clearly is an issue that's troubling them. Exactly what they do about it is unclear. Meaning, if you sort of say, okay, well, we're going to remand and say, and tell the judge, okay, you can't have the strict quantitative rule. Well, the truth is, she really did it. And I think they were sort of mischaracterizing what she did. I agree with Steve. What she did was sort of really come up with these guidelines, and of course, it was one factor out of four, and so forth. So she could sort of come up with, just change some of the language and come out with exactly the same result. So I'm not sure that necessarily, it's hard to say what the conclusion flows from the issue that that they are uncomfortable with some of the rhetoric, some of the language she used about the quantification. They also clearly were concerned with respect to the fourth factor about the burden, and did the burden shift to the publishers to prove that they didn't digitally license. But at some level, that's sort of a ridiculous concern, given that there was evidence in the record that the publishers were not making digital licenses available. So it's like, who has the burden of proving? I've always sort of thought that that's kind of, this allocation of burden is a bit of it's the kind of distinction that lawyers love, but that really doesn't make a difference in the end. Because the question is there evidence in the record or isn't there? I mean, is it persuasive evidence or isn't there? And so certainly, and I agree with Steve, that once the publishers say, oh, we're losing licensing revenue, it's a fair question to say, well, are you making a license available? And who is in the position to produce that evidence? And so whether it's really a shift of a burden or just so again, that's more of a wording issue, I think, than a substantive issue. But I can see them saying, well, we don't want the burden shifted. But again, that's almost in this case, it's almost like in the harmless error category, because the evidence was very clear. In some cases, there were digital licenses available, and in some cases there weren't. And it's, it wasn't like the publisher, it's so burdensome for the publisher to prove that it was offering a license, right? I mean, they never complained about not being able to, show that they had a license. So it's a little, given that, it's sort of unclear where you go from here. And it's hard to make any prediction.
Bruce, you care to jump in?
Sure, why not? I'll jump into the fire. All observations my own, and I am not really burdened as an amicus with knowing all of the ins and outs of the record, so it's easy to pontificate when you really don't know. So with
That's
that
the joy
warning,
of being an amicus.
it's the joy of being an amicus. By the way, before I do, an aside on the is a chapter a work question, I was a little surprised nobody raised, and maybe someone did in the briefing, I didn't see it, the unit of publication rule, which I think is a rule that comes out of the Library of Congress, out of the Copyright Office, with respect to the definition of a work. And if a lot of unpublished things are all published together at one time as a composite work, that does fit within the definition of the work. And so it seems to be an argument against the idea that for these books that are published as compilations of chapters, the chapters are separate works for that purpose. Now, I may not have that exactly right, but it's something, anyway, just a suggestion for what it's worth, what you're paying for it to look into.
It was the editor's copyright that was asserted against the
Yeah,
school.
and that's right, and I think it was largely, as I recall, they waived the argument, or they didn't press the argument that the individual
Until
chapters.
mid-trial.
Right, and I thought Judge Evans said it was too late. I thought on John's point about burden of proof, well, let's go back to, we'll play a little game called, and first of all, I start with, you never know what a court is thinking exactly, and there's a long way between the argument and when they write the opinion. So all of this is probabilities, and the game is called the odds are you're in trouble when. And I already started with, after telling the plaintiff's appellant how important they are, the first thing they talk about is the scope of the injunction that they want to have issued and that they want to issue as their biggest problem. That troubles me. I am troubled by what appears to be a loss of the battle of the analogies. In the court's mind, I heard the term electronic course packs used. I didn't count them, but it was more than 5. And if you get down the slippery slope of e-reserves being electronic course packs, I think you're starting off with an uphill battle. There had to be an answer to the proposition that e-reserves are not course packs. They're pedagogically different. They serve different purposes. I don't think the court gets that, and unless they do get it, I think it's going to be problematic. I think the odds are you are in trouble when one of the judges calls your policy a sham. And I heard that, and I sort of wanted to crawl under the chair. And, they didn't get the idea that this actually is a pretty respectable, responsible policy that's consistent with what a lot of other people do, which is, so maybe they really ought to go back and read John's brief. So I have to say, I think they're wrong, and I came away a little bit pessimistic, and maybe I'm in a position where I can say that as an individual. But I do think they're about to get it wrong, and the question's going to be how badly wrong do they get it. But, fortunately, you never exactly know what they're going to do.
Yeah. Anybody else dare to play the game? This is always dangerous, too, because, judges, they like to play devil's advocate. Sometimes they're very, very hard on the position that in their heart is their own position, and so they're wanting to shore up their own faith and belief by getting the strongest possible answers to every last doubt. So this is a little bit of a fool's game. So I'll stop that. And
Thanks, thereby branding John. And
I made you play it. I
Branding
made
me
you
the
play
fool, yeah.
It's the moderator's imperative. I get to draft fools. So we've got a little bit of time left, and I know that I see familiar faces from the courtroom, and there might even be folks that were parties or amici, and I wonder if anybody else wants to stand up and ask a question of the panel or share their own kind of takeaways from the decision, from the oral arguments today. There's a little wide-range mic pointed at you guys, so hopefully it'll come through somewhere.
But just before we do that, I mean, there was one thing I wanted to mention, because
Yes.
this came up a little bit before. I guess to some extent, you asked Steve about things that were a little surprising or unexpected, and I just wanted to return to one thing that sort of took me a bit by surprise was Judge Marcus's discussion of the origin of the species, and this gets back to besides the fact that origin of the species is in the public domain. But there's this. First of all, I mean, the second factor is in the statute. It is a factor to be considered, and he said, "Gee, didn't Judge Evans give it too much weight?" I thought, well, it is true that in cases courts don't give it a whole lot of weight typically, but it is a factor in the statute, and so it's like, well, what did you want her to do? Was my reaction like, well, of course she's going to give it weight. I mean, and she didn't seem to give it more weight than any of the other factors. I mean, she gave it weight because it's in the statute. The second thing also is I was just so troubled by his not quite understanding why courts have indicated that fact works receive less protection from the perspective of fair use. It's not that they don't receive protection. He sort of said, well, if it's a fact, are you saying if it's a fact work it gets no protection? No, that's not what anyone's saying. It says that it doesn't receive as much protection under fair use, and the reason is because facts don't receive protection. Those facts are unprotectable, so fact works, you have to be very careful to make sure that when you give protection to fact works that you don't end up protecting the facts, and especially with the origin of the species, you need to be very careful that you don't lock up the theory of evolution, which is of course just a theory, we decided.
Right, and by the way, theories and ideas don't get protection either, which
Right.
is, just to expand on the principle.
Well, right, exactly. So, I mean, there is this idea, expression dichotomy. So I was just a little troubled by sort of the direction or this notion, well, gee, because it's a very important book that has very, very good ideas, that somehow that means, it should weigh against fair use, whereas to the contrary, the better the ideas and the more that weighs in favor of fair use from my perspective.
Yeah. Yeah, and that was a theme that was hammered on in some of the rights holder amicus briefs. There was also a brief from the textbook and academic authors that seemed to say, why, if Judge Evans' opinion goes forward unchallenged, then all factual works lose copyright protection. And I just thought, really? No, they lose the second factor, which is one of four, and they can fight it out with the rest, right? But that was a very common argument among the amicus briefs on the other side as well.